Hi, my name is Chris Yukins. I'm a professor of government procurement law at George Washington University in Washington, D.C. I'm very sorry I can't be there in person, but I'm very glad to be joining this international conference commemorating UNCITRAL's 60th anniversary. The focus today of this session is on mediation in public procurement and public-private partnerships for efficiency, integrity, and enforceability under the UNCITRAL text, and I'll be talking about several of those texts today. But first of all, though, I want to wish UNCITRAL a very happy 60th birthday. A special recognition of Samira Musayeva, who's worked with me for so many years and will continue to work now on a reopening, a re-examination of the UNCITRAL Model Law on public procurement. For Samira and myself, and for so many other lawyers and public procurement professionals who worked on the UNCITRAL text. I have to say that for us, the work that we've done with the UNCITRAL text in the UNCITRAL process is really among the proudest work, the work that we're most proud of as professionals. It's a wonderful opportunity to be able to make the law work better across borders, across nations, across the world. So again, very, very grateful for this opportunity to participate with UNCITRAL and participate in this special 60th birthday. So a little bit more background on myself. I'm a member of the Government Procurement Law program at George Washington University Law School. It's one of the leading programs internationally. I have decades of experience as a professor, as a practitioner in the Justice Department and in private practice as well. I worked both domestically and globally in procurement bid challenges and disputes. Those are the two types of disputes we'll be talking about today, two types of disputes that might go into mediation. A bid challenge or bid protest about the contract award typically, and a dispute that can arise during the course of contract administration, a claim typically about, for example, additional costs that the contractor claims the government owes. I worked as part of the U.S. delegation and an expert on reform of the UNCITRAL Model Law in Public Procurement, the 2011 version. I work in other procurement reform efforts as well through the American Bar Association Model Procurement Code. I'm the academic advisor to that effort. I have also done work on the revolutionary FAR overhaul that was launched by the Trump administration. I've been assisting the Bar Association in comments on those changes. I've also worked on the EU procurement directives, and which will now be maybe an EU procurement regulation. That reform effort is going to come together this fall. It's going to be an important part of what's done with the UNCITRAL Model Procurement Law. And I also worked on assisting in implementation of South Africa's Procurement Act 2024. The Commission has decided to launch a working group to review the UNCITRAL Model Procurement Law, the 2011 version, and that working group will meet in February 2027. And the specific topics to be addressed are outlined in a document prepared by the Secretariat. I've cited it here. And most specifically, if you look at pages 10 to 11 of that document, there's going to be serious consideration of how mediation can be used more effectively in public procurement. So we discussed this relaunching of the UNCITRAL Model Procurement Law, the targeted review of the UNCITRAL Model Procurement Law in a webinar we've been having in this month. At the July 20th session, we had a very focused discussion of what possible areas of reform might be. And that session is available at publicprocurementinternational.com. You can see the recording of the session there if you want to get more information on where there might be points of reform in the UNCITRAL Model Procurement Law from 2011. So I want to address the two areas of procurement disputes, the two types of procurement disputes that are most likely to be amenable to mediation, and then talk about the pros and cons for these different types of disputes. So one area is on bid challenges, and under the UN Convention Against Corruption, a nation, most nations are signatories to the UN Convention Against Corruption. Under that convention, signatories are required to have an effective bid challenge system. It's also a requirement of many trade agreements, such as the World Trade Organization's Government Procurement Agreement. To in a bid challenge system is clearly intended to address failures in a procurement process that lead to disappointed bidders, to legal failures, really process rules failures. Um, those legal failures that and then the need to mollify or address the concerns of disappointed bidders in order to ensure that they come back for future competitions. That's a traditional part of a bid challenge system. But what's become more apparent, we've done some studies on this through the Defense Department and otherwise through our program at GW. There's a second purpose of bid challenges, which is to disclose and address system failures. And while it's difficult to have mediation work to address the concerns of the disappointed bidder, the outcome of a bid challenge typically is yes, no. Either the award will be overturned or it won't. It's difficult to find middle ground through mediation. It's actually easier to address system failures through mediation. And as there's more and more recognition that's an important part of a bid challenge system, it's possible that mediation will be used more commonly. Now, in contrast, in performance disputes, these are disputes that occur during contract administration. It's very common to use mediation. And there's some reasons that mediation has been used so successfully in performance disputes. First of all, oftentimes what's at stake is money, and it's relatively easy to divide the damages or to as a mediator to figure out a way to use a common phrase to split the baby so that each side feels like it's been treated fairly. Um, there's also oftentimes a uncertain law which lends itself to resolving a dispute because both parties know that the law is uncertain. It lends itself to mediation, to resolving it through mediation. And the reason the law is uncertain is kind of interesting. Is because in most systems, this is not true of the federal system in the US, but in most systems, contract disputes are being litigated under normal commercial law. That's very common, for example, in the states in the United States, because there's not a mature body of contract administration law. There is a mature body of contract formation law, but not administration. And because of that, standard commercial allocations of risk are used, but those allocations actually don't work always well in the public procurement context. So it creates an uncertainty in the law and again makes mediation more attractive. There are also oftentimes uncertain facts. If there's a delay in a project, for example, who's to blame for that? How can one retrospectively, in a reliable way, sort out what the appropriate schedule of the project was? A lot of uncertain facts. And because of those uncertainties, the uncertainties regarding facts, the uncertainties regarding the law and the money damages, very oftentimes mediation can work quite well in a public procurement dispute. So just some specific examples. We see in South Africa implementation of the Procurement Act of 2024 that the Procurement Act allows for even untimely bid challenges at the procuring agency if the procuring agency might have an opportunity to address an issue of public interest, of public policy. There's a recognition there that the challenges can serve a broader public policy in addressing and unearthing problems. In the U.S. government, the bid challenges are generally viewed as difficult to mediate for the reasons we've talked about. There's zero sum, but also there's problems because the arbiters tend to be focused on the decision and not on fixing not fixing the public policy problem that the challenge presents. Contract administration claims in general are regularly mediated, as I mentioned, sometimes even by the contracting officer who has the right of first review when a claim is going to be brought. And in fact, the Part 33 of the Federal Acquisition Regulation specifically contemplates assistance by unions, by neutrals. The European Union, in its remedies directive, which governs challenges, it specifically contemplates interim corrective measures. The idea that the remedies process would work best if there's an early remedy of the problem that has created the bid challenge in the first place. All of these different approaches to mediation would be helped a great deal by the UNCITRAL Mediation Rules from 2021. They bring structure to the process. With that, I want to wrap up, and I've included my email address here if anybody wants to reach out. And thank you very much for your attention. Bye bye.